Good morning, Your Honor. Mr. Chief Justice, members of the court, may it please the court. I am Ben Sessions on behalf of the appellant Omar Awad. This appeal arises from the order of the trial court granting the defendant's motion to exclude evidence of his refusal to submit to a urine test that was requested of him following a DUI arrest. The relevant facts of this case are fairly straightforward. Mr. Awad was arrested for DUI. He was read the implied consent advisement. The officer in connection with the implied consent advisement requested that Mr. Awad submit to provide a urine sample for testing. That urine sample was to be provided into a cup. It was not to be drawn by catheter. Those are facts that are really important to this appeal and to this case. I'd like to cite the court to the reference to the record to page 35, lines 9 through 13. That's where it references how the sample would actually be collected. The reference to with regard to the catheter and the lack of use of a catheter by the state in attempting to obtain this sample, those references to the record are at page 6, lines 9 through 18, page 35, lines 9 through 13. In addition to those facts that were proffered by counsel at the hearing on this motion, the state also alluded to there being a temporal element to the request for a test. They said, this is a sample that the defendant must provide, and he must do it within a fairly short period of time. They used the language of, the officer's not going to wait for 4 hours for him to give it. That also lets the court know this is a test that the defendant must in fact provide the sample for. The state
counsel, let me ask you, so is it your opinion that based upon them specifically saying that the cup would be the vehicle by which they would get the sample, that eliminates other possibilities for collecting the urine that might not be compelled by the defendant?
That those other types of means of obtaining a sample, Your Honor, that would involve not an act by the defendant, it's part of the facts. That statement is obviously very important in making that determination, but also the proffers that I made to the trial court that were on page 6, page 35 of the trial, the motions transcript are also important.
So it sounds like you're saying there's no definitive thought about how the urine would be collected, because you agree there are ways to collect the urine that wouldn't be compelled.
Your Honor, there are means of obtaining a urine sample that don't invoke the self-incrimination provision. Those means, i.e. a catheter, do not involve the defendant performing any act. If the state were to extract urine from the defendant, i.e. like Kramer, then you're in a position where you don't have to consider the self-incrimination provision.
Well, let me ask you this. Is the record clear enough where we can opine on anything? Your Honor,
I think that's a great question. First, we have a case that's Rank versus Rank. It's 287 Georgia 147. It was decided in 2010. It's an opinion by the Chief Justice that deals almost exactly with this type of scenario. You have proffers by counsel that were never objected to at the hearing. There was never a single objection that was ever lodged by the state at the hearing on the defendant's motion in this case. There was never any effort by the state to say even, Judge, would you hold on for just a minute? I'd like to clarify for the record that is not in fact how the sample will be collected from the defendant in this case. There was never even any insinuation whatsoever at all by the state in this case that they attempted to obtain a sample by means other than Mr. Awad urinating into a cup.
Well, and if they were going to do it by catheter, you would need a search warrant, right?
Your Honor, I believe there are
before the state injected a medical device into your body and forcibly extracted fluids from your body, that would be a search of your body, right?
Almost every set of circumstances would require a warrant, Your Honor, except there is a recent U.S. Supreme Court case that dealt with drawing it from an unconscious defendant, blood that was. So I do believe that Good under certain, I'm sorry, Your Honor.
No, go ahead, finish your thought, and then let me ask you a question.
But that would be, well, maybe not a warrant, but that would be a search of the body, right?
That
Not,
would be, Your Honor. Yes,
Not
that's
every-
correct, Your Honor.
Let me give you a hypothetical. Suppose they placed the defendant in the holding cell. They turned off the water source so that if and when he used the urinal, or if it's a female, the toilet, that they could capture the urine there. That would bypass Chief Justice Nomnia's scenario, as well as the scenario of the cup.
Absolutely would, Your Honor. That is
So-
absolutely a scenario in which they would. It would be like, for example, in the case where a defendant was called upon to stand up in the middle of a trial. Instead of asking a defendant to stand up in the middle of the trial, if you had just taken a picture of him outside the courthouse with him walking around with one leg, you would have obtained that evidence by other means, but it would not have been.
So, Mr. Sessions, this is a strange issue, right? So on the self-incrimination spectrum, you've got deep lung breath, being voluntarily blown out at one end. That's a test that cannot be done without consent. It just doesn't work unless a defendant is performing voluntarily. And on the other end of the spectrum, you've got a blood test where it doesn't really matter what you do. And doesn't implicate self-incrimination. And in the urine test context, because there are different ways to do it, those different ways are at different places on the spectrum. Some of those ways, in my view, implicate self-incrimination, and some of them don't. And when we're dealing with the result of a refusal, where in fact there was no test, whose burden is it at the motion? If the record is silent about the nature of the test, and we know that one of the tests that could have been chosen would implicate self-incrimination, and one of the tests that could have been chosen wouldn't, whose burden is it, and how does that affect what we conclude from an ambiguous record?
I believe it's the state's burden, Justice Peterson. I do believe it's the state's burden to show that there was in fact error in the findings of fact by the trial court that were there. They were never objected to at all. And in fact, if you read the transcript, the state actually asked for reconsideration, and the only thing that they asked for reconsideration on was just for the application of Green and Robinson. They never said, Your Honor, hold on for just a moment. This is a case in which their defendant wasn't actually going to urinate, wasn't being called upon to voluntarily urinate into a cup. He was going to be strapped down, and we were going to extract urine from him, which would in no way, shape, or form invoke the self-incrimination provision of the Georgia Constitution. If that was in fact the case, that was the state's burden. They certainly cannot lie silent at a trial court, not say anything, and then come back on appeal and say, hold on, the record's silent because we didn't tell you guys and we were keeping it a secret, that sort of thing. And now we believe that there's an error. That was a chance that they were taking at that hearing. And it's clear from the transcript and the actual statements by counsel before the trial court that there was never going to be a catheter. It was a urine test that was going to be.
Let me ask you this on that very point, and referencing the Chief Justice's question earlier. If there was a warrant, if there's a search warrant, I mean, the catheter question would be resolved, right? I mean, there wouldn't be any consent question involved, right?
Your Honor, that's correct. That it is not in. If you have a warrant and you have a defendant who's not being asked to, would you provide this sample to us?
Yeah, my point is, if there had been a catheter here, there would have been a test performed. I mean, if that's what the state had intended to do, then there would have been a sample drawn and there would have been a test performed. And the question would be, can we suppress it because we didn't consent, or because it's self-incrimination, right? I mean,
the only issue. Go ahead, Justice Warren.
But do I understand, counsel, that of all these different methodologies that we have discussed about taking a urine sample, that of all those different potential options, catheter, using a toilet with a false bottom, allowing someone to voluntarily urinate in a bucket or a cup, that the only scenario that you're saying invokes a self-incrimination problem is being compelled to urinate into a cup or other receptacle?
That's correct, Your Honor.
Okay.
It is, and this is a scenario that the trial court was informed of in this case. If you had a false bottom
Right.
toilet or portalette or
I
whatever.
mean, one of the problems with this, and I'll ask your opposing counsel, I mean, we have a case here to decide an important constitutional issue. One of the problems is everybody in the courtroom knew exactly what kind of test was going to be performed. If the state had gotten up and argued something out, they would have been laughed out of court. And so that is one of the problems with the scenario here. So maybe just turning to the legal issue. And let me start by asking, our cert question was actually, did the trial court err in its conclusion? The trial court is bound by our binding precedent in Green, right?
Your Honor, I don't believe that Green is still good law in light of.
We
Elliott and
expressly
Elliott.
said in Elliott that we were not expressing any opinion about whether Green and Robinson were rightly decided, right?
Yes, Your Honor, that's correct.
So Elliott does not overrule Green.
That's correct, Your Honor.
And
Okay,
Green
so
is
Green
differently
is-
postured, isn't it?
So the trial court erred. I mean, who gets to overrule Green?
I believe the trial court probably overstepped its bounds, Your Honor, in making this decision.
Okay. All right. But we still have to decide whether Green is good law.
Yes, sir. Yes, Your Honor.
Maybe you could speak for a couple minutes on that, why,
Yes, sir.
particularly
Your
why
Honor.
stare decisis would not support keeping Green.
Yes, sir. Yes, Your Honor. I will. In kind of moving through the Jackson factors that were discussed in Jackson versus State, and obviously at length in Olivick and Elliott, the analysis that was applied in Olivick and Elliott's equally as applicable to the stare decisis considerations in this case. But I'd like for the court to recognize that there's virtually no other cases in the state of Georgia that have relied upon Green and Robinson for the proposition that urine tests do not invoke the self-incrimination provision. Of approximately 61 cases that have in some way, shape, or form referenced Green, there's only one, at best, two cases. Those were Elliott and Olivick. Those two cases are the cases that reference it with regard to self-incrimination of a urine test. So
Is that
it's not a.
Counsel, is that perhaps because Green involved a probationer?
Your Honor, I believe it primarily involves because we just don't see many urine test requests. I believe that is the predominant basis for it.
To Justice Colvin's question, though, it was my reading of Green is that it was a condition of probation to submit to these tests. Why couldn't we read Green as really being about waiver as opposed to a constitutional holding?
Your Honor, I completely agree in that regard. I'm not even sure that Green even necessarily controls this issue. It has that one section in it that just explicitly, although not an extensive analysis, it is just sort of thrown in there that this, because it's naturally excreted, it doesn't invoke self-incrimination. But the waiver portion, as it relates to the person being on probation, at the end of the day, was going to control the admissibility of that sample that was submitted.
It might control, but Green separately argues it as a non-waiver issue. I mean, or addresses it as a self-incrimination issue and squarely holds that it's not a problem.
It does, Your Honor, but it at the same time provides no analysis whatsoever as to whether or not the defendant had to perform an act or whether or not that sample was to be extracted or merely collected from him in the natural course of urination. If you wait there long enough, you can obtain a urine sample from a person. You're not going to obtain it within that sort of temporal constraints that the state's alluded to in this case, but you could eventually obtain it, and that would be a sample that would not invoke self-incrimination. It'd be like the false bottom of a toilet, for example, to collect it. So there is certainly in Green, it fails to in any way perform an analysis of the means by which the sample was to be collected. At the end of the day, how the sample is tested itself has no bearing upon whether or not the self-incrimination clause of the Constitution is invoked. It's how the sample is collected and whether or not there is an act by the defendant that ultimately produces that sample that will eventually be analyzed.
Counsel, can I
In
ask?
Green, there was no consideration.
Counsel, can
Yes,
I
Your
ask a question that's not obviously presented by the facts of this case, but it occurs to me as possibly relevant to the argument you're making. Let's assume that a citizen, based on a condition or a recent medical procedure, is in fact catheterized when they are stopped by the police. In other words, they currently have a catheter in place. Can police take the sample then because it doesn't require some positive act on the part of the, in other words, can the police, can the state manipulate the valve and take the sample?
With consent, Your Honor, or some other extant circumstances that might support.
Or a
that.
warrant, right? I mean, if the state got a
Correct.
warrant to remove that particular evidence, self-incrimination would not be
That's
at
correct.
issue, right? Because there's
Yes, Your
no,
Honor.
Well,
Okay.
let me back up and say not with a warrant. That, I mean, because I think we've established that with a warrant we can do the state can administer a catheter. My question is, I'm trying to delineate where you think the line of self-incrimination is. Is it in fact, I mean, the physical act of urinating, where you know, of the individual, or is it just merely that, you know, urine that is secured from the person without their consent? I mean, where is self-incrimination? Where's the self-incrimination line?
Your Honor, it would require some act by the defendant performing some act in order for the self-incrimination provision to be invoked. So if, for example, the officer called upon the defendant and said, "Sir, will you open the valve so that I can collect the specimen that would come out of your catheter that you already have in you?" If you call upon the defendant to open that valve, and the defendant refuses to, that would invoke the self-incrimination provision of the Georgia Constitution, I believe.
But
So
not if the officer did it on their own.
You go under the Fourth Amendment analysis then, Your Honor. So then you would determine first voluntariness of consent if it was a consent case, or if there is a warrant or some other, but it would be the Fourth Amendment that would control that search, not paragraph 16 self-incrimination provision that would control it.
Thanks.
Yes, sir. Your Honor, in moving through the remainder of those of the stare decisis factors that the court was asking about earlier, reliance interests, it was made abundantly clear in Olavic that if the law is improper and this procedure is improper by which we're using a person's refusal to submit a urine sample, that should not, the reliance interest shouldn't prevail over an improper construction and application of the law. And then in terms of workability, we know how workable this rule would be in practice because we have seen that, in fact, Elliott has been workable in hindsight. It has not posed a problem at all for trial courts in applying the rule and the holding of Elliott going forward, even despite what the case law had said for 20, 30 years prior. So it was
your friend across the way may disagree with you on that point, but
it may be a problem for prosecutors. I understand that. It has not been a problem for trial judges in delineating what evidence is and is not admissible and applying it going forward. So with that, if there are no further questions, I'd like to reserve the balance of my time.
Thank you, Mr. Sessions. Mr.
Thank you,
Higgins.
Honor.
Thank you. May it please the court, counsel for appellant. I'm Assistant District Attorney Mark Higgins presenting this case on behalf of the state of Georgia, the appellee in this case. The court did ask.
Mr. Higgins, can
Yes.
I just ask you a question to start off? Do you agree that the affirmation that was made, even if it was indirectly in court, that it would be the sample would be taken by giving the defendant a cup? Do you agree that that was the plan?
Do I agree that the defense counsel stating that it wasn't going to be taken via catheter should be what controls this case? No.
Yes.
Do I believe that practically speaking, it was probably going to be done by a urine sample being taken via peeing in a cup? The answer would be yes to that.
I mean, counsel, are you aware of any police department that as a matter of course has a default policy of, for example, swearing out a warrant and obtaining a sample by catheter, just as sort of the default, that's the normal way they do it?
No, Your Honor, and no, Your Honor, Justice Warren, I'm not the statute concerning implied consent and collection of urine does not specify any manner that it has to be taken. I have not found any case law that would suggest that catheterization would require a search warrant. Blood does not require a search warrant. Blood is allowed under implied consent law under the current
Well,
statute law.
it may not require a warrant, but it is analyzed as a search, right? You are required, if you forcibly take a fluid from somebody's body, you need some exception to the Fourth Amendment, right?
And I would, well, blood has been determined, implied consent has been determined to be allowed. I mean, obviously the refusal of implied consent would be something that would be admissible under the current
Well, that's
statute.
what consent means.
Yes,
right.
Your Honor. Yes, sir.
So just to put a point on it, I mean, the case is here. We can decide this constitutional issue and give clarity to everybody, prosecutors, courts, defense lawyers, and police. Or if we find the issue fuzzy, we'll kick it down the road until the next case comes up identical to this. So,
And Your Honor, I believe the courts could take judicial notice of the multiple manners of which.
well, how about rather than judicial notice, we ask you whether you acknowledge and concede the fact that what was going to happen was that Mr. Awad was going to be asked to pee into a cup.
I would acknowledge that more than likely was what was going to happen, and with a high probability. Yes, sir.
Not more than likely. I mean, have you worked on the case and talked to the people involved in the case?
I have. I did not. I have not asked the officer as to whether or not he was going to ask for a urine to be put in a cup or not. But I've been doing this long enough to understand how the process works, and yes, I would acknowledge that.
Have you ever had the experience where they haven't asked for urine in that way?
I have not, Justice Colvin.
Okay.
And just to circle back to a point that was made earlier, I mean, the US Supreme Court held in Birchfield that warrants are required for blood draws, right? Unless there is some exception that applies.
That is correct, Your Honor.
Okay, thanks.
The state's position, again, and again, we're talking about clarity on the spectrum of whether or not something is in violation of the self-incrimination clause or not. The state's position is that requiring somebody to urinate or asking them to urinate in a cup is not an act. It's just basically essentially releasing, not an act as under self-incrimination clauses. The court has several cases where the court has found there not to be an act in violation of self-incrimination clause that all involve taking items from the body. Quarterman versus the state is a felony DNA case whereby DNA was not found to be in violation of self-incrimination.
That's where the state takes something from the body, right? That's the submission by the defendant to the state taking evidence from the body.
Yes, and the court has found that
It's not a voluntary act affirmatively by the defendant to create evidence, right?
Well, I mean, again, you can split hairs, I think.
That is the distinction that Elliott and Olivic draw.
Well, from a standpoint of, Olivic seems to be decided solely on this deep lung breath concept as opposed to just normal substances being taken. For instance, in Quarterman, nobody's suggesting that in Quarterman, the fact that you ask somebody to open their mouth so that you can take a buccal swab of DNA is requiring them to submit to an act.
Do you see the distinction though between the two? Because I think Olivic also talks about the difference between regular breathing, the breathing that you and I just do while we're talking, and the kind of breath that's required for this particular test. And so when an officer asks for that particular kind of breath, just the officer couldn't, for example, just capture the breath in the course of the conversation. It requires this act and this deep lung expulsion. And so by analogy, that sounds a whole lot like what you're talking about here. Why is that not so?
Well, what I'm talking about here is a simple urine collection, which does not require.
Does that happen? Does that happen? I understand you're going to argue that happens naturally, for whatever that means, but that's not something that happens without some physiological things also happening.
Sure, physiological things happening. Again, you can again put it back on the spectrum. Or if you wait long enough, somebody is going to urinate, and that's the case. And the question,
if you wait long enough, deep air breath is going to come out of your lungs over a period of time, just not in a form that is useful to the state. In the same way that if you wait long enough, a defendant is going to urinate, but not into your cup. And so it is the act of putting it in the cup that is the voluntary act that is not the ordinary, natural occurring way of doing things, right?
Well, and again, I don't know that just the release of the urine into the cup is a act in violation of self-incrimination.
It's not an act violating self-incrimination because the self-incrimination clause is compelled self-incrimination. So if I go pee in a cup, that is not self-incriminating. But if the state forces me to do that, that is compelled. And then if the purpose of that is for the state to collect evidence from me, that is compelled self-incrimination. The word compelled is pretty important here.
And part of the compulsion is saying, do it in this manner now. Not, I'm going to sit here and wait to see what happens in 4 hours.
Do you agree that if the state forces me to say certain words out loud for the purpose of collecting evidence, something even the Fifth Amendment would cover, that is compelled self-incrimination?
Absolutely.
Okay. The state could wait around until I say words, or they could go out and collect those words with wiretaps or through other people. That is not compelled, but they're the same words. It is a requirement that I do it at a particular time and in a particular way that makes it compelled self-incrimination.
Well, and again, looking at Quarterman and the Thornton case, impressions of teeth case, the idea that because the officer taking or compelling the person to provide the dental imprints or the DNA has to open the person's mouth or ask the person to open the mouth, and that person then has to open the mouth. The courts have said in all of those cases that that's not an act in violation of self-incrimination. Quarterman, the court did not find an act in violation of self-incrimination.
Did any of the acts, does my opening my mouth incriminate me in any way in that case?
No, Your Honor, it does not.
Okay, does the lifting of my shirt, does that act incriminate me in any way? Again, it's compelled and it's self-incrimination. If it's not incriminating, then it's not a self-incriminating compelled act.
Nor does the providing of urine in and of itself, Your Honor, compel anything or self-incriminate you. I mean, the urine is not tested, unlike the breath test where the urine goes, where the breath goes through a machine, it has to be blown at a certain level for the machine to capture it. The urine test is essentially the collection of the urine that in and of itself is nothing until it then goes to a lab and is tested. So at the time it's being given, it's not self-incrimination at the time the urine is provided, Your Honor.
Why are you trying to get it?
Why are you trying to get?
Why is the state trying to extract urine from a person arrested for a DUI?
The state is obviously attempting to get urine as evidence against them. And again, I think the other cases would have the same analysis. Taking blood-stained clothes from the defendant was found in Franklin not to violate self-incrimination. Again, the Quarterman case, DNA, Thornton versus the teeth, and Kramer involving the taking of items via surgery did not involve self-incrimination. Again, the fact that the defendant makes it easier doesn't in and of itself invoke an act under self-incrimination, at least is the way it appears in the case law that has been set down, that has been discussed in Olivic and Elliott. At the time, the other thing that the state would like to point out is at the time of a request and at the time of a refusal, when the state is asking for a urine test, that urine can be taken multiple ways. And at the time that that test is being requested, with a statute that allows multiple ways for that urine to be tested, the defendant is making a decision as to whether or not to refuse or not to refuse, with multiple manners from which that evidence could be collected. Because there are multiple manners from which that—
Counsel, let me ask this. Whose burden is it to demonstrate what it is that the defendant refused? So if there's multiple ways to do it, and if you say, if you said to me, would you come over and help with some yard work? There's multiple things that could mean. And if you said, well, what you declined to do was pick up leaves, and I said, well, I didn't know whether to pick up leaves or mow the grass. Whose burden is it to demonstrate what it was that was refused?
And
Well,
counsel, I
again—
thought you agreed initially of the manner. So I'm kind of confused. Are you going back now to say it may have been taken some other way?
No, I'm not disagreeing. I'm just saying at the time of refusal is made or request is being made, there are multiple manners from which.
And that's my question is who is responsible for saying for proving what it was that was refused by a defendant?
Well, again, from a standpoint of the court should not make a ruling without a knowledge of that. Obviously, the statute that's in existence would allow any method of.
Aren't you refusing every method? If you're asked, can I take a urine sample or can I give you a chemical test for urine, and you say no, aren't you saying, no, you can't, I'm not consenting for you to search me. No, I'm not going to give it to you voluntarily. No to everything.
Absolutely. And that no would also include every method again.
So not necessarily, Mr. Higgins. Let's say that we were to overrule Green and adopt a rule that urinating into a cup at the direction of law enforcement does implicate self-incrimination. And so there's a right to refuse and not to have that refusal used against you. But a urine test via catheter doesn't implicate self-incrimination. And so if you refuse that, if you refuse to be catheterized, that refusal can be used against you. Wouldn't, at a motion to suppress, it then be the state's obligation to prove that the refusal was of a catheter, given that the state has the burden at the motion to suppress?
Yeah, sure. I believe that would be the case, that the state—
Which would then require you to show to show to the judge's satisfaction that you had asked the defendant to submit to a catheter, right?
I would agree with that, Your Honor.
Okay, thank you.
Again, I believe the state's position again is Green is consistent with Olovic. It's not in contradiction to Olovic or Elliott, which I believe was decided on this unnatural breath required. In Green, the factual considerations in Green that are different is that the taking of or collection of the urine in no way enhances or changes the nature of what's naturally occurring. And I believe Green's decision that it was naturally occurring, the same way the court has asked, how was it going to be taken in this case? I think it's clear that in Green that it probably wasn't going to be catheterized either. To suggest that 31 years ago that Green did not understand that concept the court in Green obviously understood that. The decision was made that it was naturally occurring. In other words, it wasn't being changed.
The court in Green did not have the benefit of all the writings in Olovic and Elliott, did it? Because as you say, those writings happened 30 years later, 29 years.
Actually, many of the cases I believe were cited in Robinson versus the state, the Court of Appeals decision that Green relied on. So I would say,
Have
Yes.
any of the cases that Green relied on been overturned?
Not that I'm aware of, from a standpoint of, I believe Robinson was overruled on some other point, is my recollection, but I don't recall any cases that Robinson relied on. I think some of those same cases were cited by this court, current court in the Olivic decision a few years back. So I think many of those cases are the same cases.
So you think Robinson is actually the key case? Robinson isn't even about really self-incrimination. Robinson involved samples of blood taken by a search warrant.
And Judge,
The easy answer is we have 100 cases saying if you get a search warrant, it's not self-incrimination.
and I think that's correct, Chief Justice. I think that Robinson, I think when Green applied Robinson, it applied his constitutional analysis, which was on self-incrimination. That's what Robinson.
I mean, every
Well, that's-
case that Robinson cites for the meaning of the Constitution on this point was a case holding that the evidence couldn't be admitted, that the evidence was taken unconstitutionally. Robinson doesn't cite a single case allowing evidence to be used.
Robinson, I believe, cites Kramer, or the Kramer decision from 1972, as well as the other cases it cites, Day, Aldrich, Armistead, were cases that were found to be in violation of self-incrimination.
Yeah, and then the long string cite that it's got, all of those are, there's the taken from cases, which are fine, but what self-incrimination is actually, they're basically just saying, look, this wasn't those things, therefore it's fine.
And I would concede that the posture of Robinson and Green both are different postures than this case, than the current case before the court. I would concede that from a standpoint of where the issue was at and where the issue is currently at. I would, but from a standpoint of the analysis and being self-incrimination, I think it's clear that this court did that analysis in Green, while it may not have been as in much detail as other courts or other individuals.
So it seems that the rule of Green is a right rule, right? Substances that are naturally excreted don't implicate self-incrimination because you're not compelled to do them. They're things that happen whether you intend to or not. The question then becomes, what does it mean for something to be naturally excreted, right?
I think that's a good way to phrase the issue, Justice Peterson. And I think, again, whether it's urination in a cup, non-voluntary urination by waiting, or catheterization, the state's position is that the court should treat those because they are all naturally occurring. There are no differences in the substance.
But so is exhaling.
Well, I would disagree. I would say exhaling in the manner that was found to be not allowed.
Right. So the manner in which the naturally excreted substance is excreted matters to whether it is naturally excreted, right?
I believe it would, Your Honor. Thank you.
Thank you, Mr. Higgins. Mr. Sessions, you have about a minute and 20 seconds.
Your Honor, I'll yield back the balance of my time.
All right, thank you, counsel. We appreciate the arguments, and the case will be decided as soon as we can.